prosecutions in countries other than the former Yugoslavia, which we have assisted in that sense in capacity building. David.
Yeah, and just to follow up on what Norm said, Bosnia and Herzegovina has actually assisted other countries that have immigrants, asylum seekers and others who have gone to those countries, and now because of the work that we've done there and the work we're doing with the ICTY and because of some of our excavation and exhumation work, we now are better suited to assist those countries in understanding how to use the evidence that we've developed to prosecute their people. But what I was going to say is just what Judge Pokar said, that Article 17 of the Rome Statute is probably one of the driving forces behind the development of domestic courts in places where there's been atrocity, Uganda, Kenya, Congo, and other places. But what the ICTY has done, again, to parrot Judge Pokar, is made the idea that you can do it credible. And what we've done by showing that domestic courts in the region can do it is to show that domestic courts can actually apply international law through their domestic law and their domestic processes and do it successfully and to international expectations with credibility.
Right. I want to ask one last question. It's one that I think I'd be remiss if I didn't ask it because I don't think it's ever asked. It was alluded I think by Judge Maloto, and I was glad he mentioned this. And this has to do with what I think is one of the most significant weaknesses when the ICTY was created, and that is the lack of focus on defense issues. This was a court that came very late, I think, in the process of recognizing the importance of providing financial support, resources, training to defense attorneys. And I was personally involved with that process with the Tadic case, and Judge Ori, who was here yesterday, I'm not sure he's here today, was in fact one of the defense attorneys for that first case. Things have improved dramatically over the years, and I give real credit to the ICTY. But as a lesson learned, as part of the legacy now of the ICTY, are we doing that better? Are we focusing in ensuring that the domestic capacity in the former Yugoslavia has this focus on defense issues? Ivan, you've talked about this. Georgia, you've talked about this. I just want to finish this with this slight focus on what I think is something that has really been left on the side for so many years, and seeing if we can say with confidence that in order to ensure that these prosecutions are fair, in order to embrace the principles of the rule of law and accountability, you must ensure that defense will have the support needed in order to ensure these fair trials.
Yes, absolutely. And it seems to me that the defense attorneys or defense community has been was a bit neglected stakeholder in the entire process. Maybe it also one of the reasons may be that it comes from a common thinking. When you create institutions to put an end to impunity, you want to focus more on those who are going to prosecute war criminals than on those who are going to defend the suspects for war crimes. But there has been also, at least from the national perspective, a problem of identifying a group that you're going to work with. Again, it differs from country to country, but in Serbia it was much easier to work on transfer of knowledge and capacity building of judges and prosecutors because they were easily identifiable, confined within one centralized institutions. Whereas it took time for us to identify who are the defense attorneys appearing more frequently in war crimes trials, simply because the defendants are free to choose defense lawyers on their own. And since 2005, we have been investing also on training and different forms of capacity building of defense attorneys. But my recommendation would be, if there are countries that such system does not exist yet, to introduce through legislation some sort of certification system, so that there are certified attorneys who are on the list that would be offered to defendants to choose counsel from that list.
Well, thank you. Judge Maloto?
I just wanted to say that at a personal level, I have had requests from the defense team, the Defense Association in Bosnia and Herzegovina. It's called OKO, O-K-O, to come and help them with their defense lawyers and give them training of sorts. And this is what I alluded to a little earlier when I was speaking. one thing that I did realize, of course, was that, in fact, in the training itself, precisely because the war crimes court in Bosnia is now going into the adversarial system, I was giving skills there which were attuned to adversarial system. And it occurred to me that there's probably a need also to include prosecutors and judges, because then you need to have all three of them reading from the same page. If the defense lawyers are going to come there and come up with all the adversarial techniques and what have you, and the bench does not appreciate them because it is steeped in the civil law system, and prosecution is also perhaps not aware of that, then
that combination is important.
That's right.
Right.
So there's a need, I think, for all of them to be involved.
To be part of it.
And of course, they can all come together as a group, or they can be dealt with separately, and in combination as they wish. But yeah, the point is there has been some little work with the defense lawyers.
Okay, good. Two last points, and we'll open it up.
Yeah, I'll try to be quick. In relation to the defense counselors and the balance that needs to be established there, I must say I can only talk about the period of 2004 and 2007, where we kind of kick-started this together with the ICTY on a local level. I think what we actually saw that the situation we inherited was really an asymmetrical relationship, because the defense counselors at the time had in fact experience working at the ICTY to a large extent. So our primary concern at that point was really to enable judges and prosecutors being acutely aware of this problem, I must say. And we have discussed this ever since, that the defense counselors need to be in fact involved in this one way or another. If you allow me just one quick point, I think there's two things that we have not mentioned, and perhaps to some extent
well, let's do this. I apologize, because I want to give everyone on the panel an opportunity to bring up any other points that we've not mentioned, but I want to do it at the last.
Okay.
I want to get to the audience. Anything? Vincent, you want to say anything on this?
Just to say on the Defense Council, I think in the case that I know best, where I worked in Croatia, this is an issue that we have been addressing very specifically, because we had experience from in absentia cases, we had experience from excuse officio nominations, where we didn't face the appropriate level of knowledge on the side of the lawyers that were defending this accused people. But this transfer of knowledge did not come out of the blue. This was part of an overall process that has been identifying elements. Also, we can talk about video link, which is maybe another legacy of the ICTY. It was not only the equipment of video links and in the courts, but it was also how to use the video links properly to ensure the proper defense of the witnesses there. What I'm saying is that we need to establish a permanent dialogue, I think, a link between the international community. ICTY is part of that, but as I said, other actors, UNDP, OSCE, and also European Union, and on the other side of the table, the national authorities. And this is what we have done in Croatia. Every 3 months, we were meeting with the authorities, meaning the Minister of Justice, who's here in the front row, the prosecutor, the Supreme Court, and we addressed a long list of issues on the agenda, how to resolve these issues, what are the identified problems, and how can we solve them. So I'm coming back to the point Judge Poca was making before. I think there has to be some kind of permanent mechanism established to allow this I wouldn't say transfer, but a sharing of experience to take place between the local judicial system and the international community.
Right. For the panel, I want to thank you. That was engaging and I think insightful, and I appreciate your involvement on this. I will let you have one last point at the end before we close it up, but now it's time to get to this very distinguished audience and to get your thoughts and questions to the panel. So I'm now opening that up for that. Now, excuse me, I'm gonna try to get some. I was here all yesterday, and so I've got a sense on some of these issues that have emerged, and so I'm going to try to get some other players and participants. So if you have your sense, yes, ma'am.
Good morning, dobro jutro. My name is Stephanie Barber. I'm with the OSCE mission to Bosnia and Herzegovina. I have two questions. I'll try to keep them brief. My first one relates to what was mentioned a few times earlier about the hybrid nature of the domestic institutions that deal with war crimes cases. I don't disagree for a moment that the presence of the international judges, prosecutors, and their support staff is immediately a contribution to dealing with the war crimes caseload. I do wonder if we can assume that just because they're there, there is an organic transfer of their skills and expertise to their national colleagues. And I would be very interested to hear the views of the panel, especially perhaps David, about whether you need to have further mechanisms in place to make sure that that process happens. My second question has a slightly longer preamble. I wanted to point out some numbers. The ICTY has dealt with 79 cases involving 108 accused. The BIH War Crimes Chamber, according to the trial monitoring data kept by my organization, has dealt with 87 cases involving 104 accused since it started functioning in 2005. And in a similar period and that figure is correct up until the end of 2009, I should say. And in a similar period, from 2004 to the end of 2009, the cantonal and district courts in BIH dealt with 104 cases involving 214 accused. Now, you have to scrutinize those figures very carefully because not every case is alike to fully understand their meaning. But I think what is obvious is that both international, national, and local level have made a significant contribution to dealing with the legacy of war crimes cases. But we also know that the cantonal and district courts are not like a mini tribunal and have very different conditions. So my question is, how specifically can we concentrate on building the capacity of the cantonal and district courts, which will continue to be involved in war crimes cases for many years, according to Bosnia's national war crimes prosecution strategy? And how can the ICTY play a role in that? And I particularly want to push the envelope on that question and say, what can we do beyond training the people that are there? What can we do to give them more resources and put more at their disposal?
Thanks.
That's it. Thank you.
Thanks very much. Excellent question. Let me, as you all think about these questions, if I feel like there's a question I want to immediately answer, I'm going to do that. And I think this is one. I think it was an excellent question because this issue of the hybrid nature of the courts in Bosnia has also gotten some play, as I mentioned earlier, about some of the other domestic war crimes courts that are emerging in other countries. The argument that actually for domestic courts to coming out of post-conflict environments, that it's really a significant risk to undertake these types of trials without significant international support and involvement through a hybrid nature type system. And so on that point, I want to ask whether or not your views on this hybrid nature she's asking.
Mark, I made something on Kosovo on this one too.
I'm sorry?
On Kosovo.
On Kosovo? Was that on Kosovo? On there? Kosovo as well.
Well, Stephanie directed one of